how to better promote homeowner and HOA education, and we are glad to be part of the conversation about potential legislation on that issue. In closing, again, we appreciate the members' time and the invitation to speak on this important issue, and we welcome you to reach out to our office as you continue to your work. Thank you.
Thank you. Do any of the members have questions? Okay, Representative.
Thank you, Mr. Chair. Thank you for the presentation. I had a question. Well, first off, I appreciate you enlightening us about the capacity of DOJ when it comes to HOA disputes, and I certainly appreciate hearing about how you all track things, that these HOA-related complaints are part of a more general process of tracking complaints. My question is, let's see, is it advertised in some way that DOJ is able to receive HOA-related complaints?
So we advertise, we have very prominently on our website file a consumer complaint. We don't specifically invite HOA-specific complaints, and part of that is for the reasons I was describing about what our courts have said on sort of the nature of HOA complaints, and sort of our primary statute that we enforce is Chapter 75 of the general statutes about sort of the general consumer protection statutes. And the Court of Appeals has been very clear that that statute does not cover HOA disputes.
Okay, thank you again for coming out. And if you would give us a written copy of your statements today. All right, the last but not least is the North Carolina Real Estate Commission. It's my understanding that the legal counsel is not going to be able to be here today, so we have Miriam Bayer. She's the executive director for the North Carolina Real Estate Commission. Thank you for coming out today.
Thank you for having me. Good morning, everyone. My name is Miriam Bayer. I'm the executive director of the Real Estate Commission. The Real Estate Commission is an occupational licensing board charged with regulating real estate brokers. We receive consumer complaints about our brokerage community, and we have a staff that manage those complaints. We do not currently have any jurisdiction over homeowner association managers unless they happen to be licensed as a broker. If they happen to be licensed as a broker, then we will receive a complaint about their conduct, and depending on how it relates to their broker license, we might make an inquiry and investigate further into it. We had a number of specific questions that were asked of us. One was what the Commission currently does to track homeowner association complaints. Currently, we have a system that only allows us to categorize our complaints into one topic, and usually complaints that come to us cover a number of different topics: contracts, agency, homeowner associations, money, all kinds of things. Like the DOJ, we're working on an upgrade to our system, and so we should be able to track more thoroughly the different kinds of complaints that come to us. We also were asked for information we've collected on complaints so far, and as I've said, we can't really do that at this point. What additional steps the Commission would have to take to track complaints in a systematic way? Again, I think we could do it. Certainly, if you wanted us to do it going forward, we could do it manually until we have the computer systems available to us. We currently receive somewhere in the neighborhood of 1,200 to 1,400 complaints a year about brokers in general that we handle, and so we could also do a manual search of those complaints for a short period of time to give you a sort of a bird's eye view of what might have had a homeowner association mechanism attached to it. Finally, you asked what information about HOAs we currently have available to licensees and to home buyers and consumers in general. We do have a couple of different brochures. We've provided hyperlinks for those brochures. They can be downloaded as PDFs, or you can buy a color glossy pretty one. One is about residential subdivisions and planned communities specifically. One is about condos and townhomes, which have their own set of laws and rules that govern them. I would be happy to try to answer any questions that you might have.
Does the committee have any questions? Representative Eiler.
Thanks for being here. I've got a lot of friends in Brunswick County that are brokers, a lot of that are developers. I've got a lot of them that are declarants on HOA agreements. So am I understanding that you would receive complaints even if a broker is not involved?
No. We would, if a broker, so there's overlap in community association management. You don't need a real estate broker license to be a community association manager, but we have brokers who are licensed who choose to also operate in that arena. And so if a broker is licensed and they perform community association management services and a consumer has a complaint about how they do that, then we'll receive that complaint. But we have to have jurisdiction over the licensee and or the company involved in order to investigate a complaint against them. So if they happen to be licensed as a broker, then we'll look at that. We actually have rules that say that if they are licensed as a broker and they are managing an association and receiving money, they have to handle the money that they receive in the same way that a broker would have to handle trust money. They have to operate as a fiduciary. They have rules from us about how they account for that money, how they report the money that they have. Sometimes they complain about that because it puts them on a different standard than their competitors who are not licensed as real estate brokers and don't have to follow the same rules.
Okay, follow up. One of my first phone calls years ago was from a homeowners association that was supposed to take over the roads and stormwater system from the declarant or the developer. Developer, I believe, was a real estate broker also, but they said, well, it's not up to par, so we're not going to take it over. That was my first dispute. If HOA board has a issue against the declarant or developer who happens to be a broker, would that be something that would rise to the occasion of Real Estate Commission?
Well, so we would certainly look at it. I think in the end, we would probably conclude that that was a civil dispute. What we have the authority to do is to discipline a broker if they violate our law and rules. So if they lie, they cheat, they steal. So if there were something like that happened in the context of the transaction that you're describing, the takeover of the community, maybe they didn't disclose what they knew and should have disclosed about the state of the roads or who's got responsibility or something of that nature, then we would have the authority to reprimand, suspend, revoke their license. And that would be the extent of the authority that we have. We aren't like a court. So we can't order somebody to pay somebody else money. We can't order somebody to do something affirmative or stop doing something that's bad. We can only reprimand, suspend, or revoke or accept a surrender of a license from a broker.
Okay, I think they went to Silver Court and got it resolved over a period of years. Okay, well, again, there's other things about who's running the HOA, declarant or the board, or who's appointing the board. So I don't know if you get into all that or not, but I'll hold that for another day.
Okay. Well, we'd be at your service, and if any of you want to give us a call and ask us more specific questions, we're happy to do that. Or if you have things you'd like us to provide to the committee as a whole or to the General Assembly as a whole, we're also happy to do that. Thank you very much.
Thank you for coming out. Please give us any notes that you may have on your presentation. Okay, that concludes the comments and question and answer for the all of the various agencies that were here today and organizations that represent HOAs. Now we'll have some public comment, and it looks like we finished up in time to probably have everybody that signed up able to ask questions. We will have to limit you to 2 minutes, though. The first is Dawn Schildenhorn. I hope I said that right.
My name's Dawn Schildhorn. I am a homeowner. Thank you so much for giving me the opportunity to speak today. I'm just going to give you my opinion as a former prosecutor and a homeowner in a North Carolina HOA. CAI lobbyists and its CAI attorneys are not concerned, in my opinion, that HOAs will not be able to pay their bills if reform passes, as has been previously suggested by the CAI lobbyist. This will never happen over small amounts like $50. There was a $50 lien filed in a famous solar panel case that went to the Supreme Court, and other liens and foreclosures filed by that same firm. That's ridiculous. Lobbyists and HOA attorneys fight legislation that will negatively impact their business. One lobbyist law firm alone represents over 1,000 HOAs in this state. Oversight could dry up much of that business. Proposed caps on attorneys' fees would further limit their profits. In the solar panel case that I mentioned, that firm made lots of money when their HOA client lost. Lawyers have everything to gain with costly litigation, while homeowners have everything to lose, including their houses. With oversight, many cases would never be litigated. That would greatly benefit homeowners to the detriment of the lawyers. Further, the North Carolina CAI collects $4,800 from many elite sponsors, like landscaping companies who seem to pay to play, with promises on the CAI's website of free advertising, promotion, and long-lasting connections to HOAs who have million-dollar contracts. In my community, the CAI's recent past president is an employee of our management company and has helped hire several of these CAI donors with homeowner funds. It is therefore not surprising that the organization's lobbyist opposes management company contract limits, which will hurt the business of many of their members and sponsors, including the past president, who arrogantly told me that he answers to no one and means it, because the CAI apparently bestows that kind of power. A lack of education is not the problem. Laws without oversight will continue to be flouted without enforcement and repercussions for violations. In my community, the CAI attorney does not provide requested documents regularly, including the management contract. Homeowners need venues like small claims court and oversight office to prevent and right countless wrongs. Maybe these management companies need to be licensed so that they can be held accountable for their business. Please don't be swayed. Your bill could benefit more than 3 million North Carolina homeowners who need your help. Please help us. Thank you. Thank you, sir.
Thank you. And if you would, please give us a copy of your notes. All right, next we have, and I apologize, but I'm having a hard time reading your writing. Is it Yolanda White? Is she here? Miss White? Okay, thank you.
Good morning, ladies and gentlemen of the chair. Today I stand before you to emphasize.
Let me interrupt just real quick.
Sure.
Would you say your name again?
It's Yolanda White. Good morning, ladies and gentlemen of the chair of North Carolina Homeowners Coalition. Today I stand before you to emphasize the concerns of the Lenox Square condominiums of Jamestown that are retired or seeking retirement and have sold their homesteads and downsized to a comfortable living condominium or townhouse. Just picture, we are committed retired volunteers and Sunday school teachers, leaders in the community, serving the homeless and the hospice homes. We emphasize the need for reform and collaboration that would ensure transparency, fairness within the community, deter overreach HOA managers' interference, to encourage open dialogue with constructive solutions to improve the homeowners association for the benefits of all residents. These meetings provide a vital platform for fostering community engagement, addressing homeowners' concern, and collectively working toward the betterments of our neighborhoods. Together, we can continue to make a positive impact on the lives of the North Carolina homeowners. And thank you.
Thank you for coming out, and if we could, for the record, get a copy of your written presentation. Next, we have William Keller.
Thank the members for listening. My name is William Keller, live in a Del Webb community by Pulte Construction. I've been past president of an association in Virginia for 7 years, so I know a little about HOA management. I want the legislation upcoming to possibly include stricter requirements for these developers while they act as the board of directors. These developer boards are very secretive. They will not disclose decisions. They do not, as the law requires, notify members when they have meetings. It's very difficult to even get responses to many questions that we have. Having over $600,000 a few months ago, none of that money was invested in any kind of a account where there was interest. It took months to get them to do it. Now they got another $200,000 that we can't get them to invest either. I don't know what the problem is there. We'd like the oversight we would like to have oversight in what these developers do and how they do it. They do have fiduciary responsibilities. The management companies also, in our case, have been very reluctant to give us information or even answer our questions. We have an amenity center that hasn't been opened. We've lived there for 2.5 years, yet they're collecting dues every month, which is why we have such a large accumulation of money. And we feel that the developer has done this in order to mitigate his expenses for operating the amenity center when it is open. We've had to pay in advance for that. So understanding that management companies that management companies serve at the pleasure of the board of directors, we understand that the board of directors may suppress what the management company can and can't do. Understanding that, we would ask that this legislation includes more requirements as to what management companies and these developer boards are legally able to do. Thank you for listening.
Thank you for coming out. If you would, give us a copy of your notes.
Yeah, I'd like to know where to send it to. I only have it on my computer. Can I get an email address?
You can email it to me, steve.tyson@ncledge.gov.
Thank you, sir.
Our next speaker is Sue Hodgson.
Good morning, Chair and committee members, and thank you so much for indulgence of my brief comments. My name is Sue Hodgson, and I live in Southport, North Carolina, in a community called Cottage Point. We are an HOA-controlled community. I use that phrase intentionally because, as I've heard in other comments, HOAs, depending on their board members, can become burdensome, almost overwhelming to the communities and residents to which they're supposed to be in service. I believe that the primary issue for residents being unable to get effective, non-threatening service is that homeowners associations by law are required to register as a nonprofit. Having that designation seems to give them secret society status. Residents that fund them cannot get information out of them. No information can be obtained on board activity, discussions, or even the approved construction plans for lots in the community. As an example, now you tell me, what would be the harm in our all knowing what new builds in our communities are going to look like? As an example, our HOA board gives residents 2 to 3 minutes public comment at the beginnings of our meetings and then bounce us all off the Zoom meetings as they instituted during COVID, but have continued to use to this day to suppress contact and comment from the very people that pay into the association. The actual meetings then become private. The Zoom calls are not recorded for later listening, and the minutes are scantily produced. If we deign to question, anonymous complaints are received by the board and action taken against those homeowners. Rather than working with the homeowners, HOAs often work against the owners. Big corporate management of HOAs removes all personal touch with the residents. Many boards, like I believe is the case with my own, enjoy and expect this insulation from the residents. It's detrimental to the sense of community. It becomes all business. If HOAs and their management companies are going to be all business, please consider lifting their nonprofit status and make them businesses so that they have appropriate oversight and accountability. Thank you.
Thank you for coming out. And again, I'll remind you, if you can, to give us a written copy of your presentation.
Yes, sir. Thank you. You can have that. Thank you so much.
Okay, we have one remaining speaker. It's Gene Wassel? Vasile, I'm sorry. Okay, I only have one on this list, but that's fine. We've got time, so we'll hear another one.
Good afternoon. I actually have a prepared statement which I will digress from because much of what was said was covered, and I would like to go on and enhance on some of those topics. My name is Gene Vasile. I'm the president of the Alliance of Brunswick County Property Owners Associations, which was formed in the early 2000s. Currently, our membership is constituted by 29 HOAs in Brunswick County, representing some 25,000 home and property owners. Our association is committed to sound management principles on behalf of our residents and supporting the responsibilities of our HOA governance bodies to function within the confines of the required documents under which they're organized. That is a critical issue. We have two aspects of conflict that arise. One was touched on earlier, and that is the lack of information about residents. And I applaud the idea, that concept, that this committee is looking into ways to enhance the notification process so that when people move in, they understand what their obligations are and also what the responsibilities of the HOA are. The other aspect of that is that what you have are private citizens who have little management experience and occasionally will overstep, if you will. However, what the ABCPOA does is provide training. We run a forum for our 29 organizations on management, law, obligations, fiduciary responsibilities, and in fact, tonight, we're having an attorney presentation on the Corporate Responsibility Act. Certainly, more education is helpful to alleviating the problem. Further, pre-litigation mediation that exists is a critical issue. It's something that I think, I applaud the committee looking into that. So that said, I will turn my notes over and you can proceed from there. So, thank you.
Thank you very much. And we do have one more speaker. Oh, okay, I've just been notified that there are two. Mr. Timothy Hines.
Honorable members of the committee, thank you for listening. I'm Timothy Hines. I'm chairman of the North Carolina HOA Law Reform Coalition. The General Assembly has been considering HOA law reform for a long time. It's now time to establish accessible enforcement of transparency and accountability for HOA boards. This is the #1 problem cited by homeowners in polls over the years. Many reforms are necessary, but one simple and elegant way to move forward is to allow owners to receive relief in small claims court for an association's denial of the owner's valuable right to inspect and copy association records. Other states do this already. For example, California's Civil Code provides that a member may bring an action in small claims court to enforce that member's right to inspect and copy association records. It also protects associations from frivolous actions. Thus, it gives homeowners access to real enforcement of transparency and accountability without risk to honest HOA boards. I asked the committee to recommend the attached legislation, which I'll provide. It spells out what constitutes association financial records and accounting records. It requires that they be maintained or made available in electronic format. It gives owners the right to relief in small claims court if an association unreasonably withholds access to those records. General Assembly has gone around the mountain on HOA reform a lot of times. It's now time to act on at least this small step toward effective and accessible enforcement of homeowner protections through association transparency and accountability over records. I've attached the proposed North Carolina bill and the California law that I mentioned. I thank you for your time and attention.
Thank you very much. And if you would give that to the Sergeant of Arms, and we'll make copies and make sure all the committee members have that. Thank you.
Thank you.
I would like to point out one thing, that the audio from the last committee meeting that we had is available online at you can look up this committee, this interim committee, on the legislative website, and you can access it there. And the one that we're doing today, the meeting we're having today, will also be available. Next speaker, and the last speaker, I believe, is Bergen Wessel.
Thank you. My name is Penny Von Bergen Wessels. I'm a member of the North Carolina Citizens for HOA Reform. I'm sure your eyeballs ache from reading all the HOA horror stories, because I know mine do. So I'm not going to tell you another one. 10 years after the North Carolina Planned Community Law was enacted, a select committee on HOA reform was established. Its 2009 findings closely parallel what we're dealing with today, 15 years later. The number one complaint in 2009 was the lack of an enforcement mechanism for the laws that exist. In the intervening 15 years, a number of states have tackled the problem. South Carolina tracks and publicly exposes errant HOAs, and even without a mediation component, there must be a salutary effect for an HOA being on a naughty list. Personally, I'm impressed with the Delaware approach. Not only does that state investigate and mediate, but egregious actions are referred to the Attorney General. So no one needs to reinvent the wheel. One only needs to perfect it for North Carolina. Enforcement, however, is only one bite of the monster problem. The other is updating and reforming current common interest laws for common interest communities. In 2011, the North Carolina Reform Committee did a yeoman's job of actually drafting legislation. It tackled secret board meetings, expanded the opportunity for member comment, further defined records access, proposed installment payments for arrearages, defined the limits of declarant control, among other things. But it does not appear that much of any of their hard work was ever enacted. So here's the chance to blow off the decades worth of dust, gather your colleagues' votes, and get the job done. Thank you very much.
Thank you. And with that, members, we'll ask if you have any comments or questions. We have 10 minutes before we're going to adjourn. So if you would, raise your hand. Representative Eiler.
I want to thank all the presenters that came today, the ones that were invited from different groups, and also the public. A couple of the public folks that spoke more recently are from my county, and they're very involved in the HOAs. And I appreciate the effort that they put in. Actually, I was involved in that 2011 committee, and we did have a lot of ideas that didn't make it into the final bill that passed. But we did a few things, but it was watered down pretty well. So, again, I'm pretty excited to, after all these years, to get back into it. And, people ask me, why do you want to tackle this can of worms? Well, it's a can of worms. I guess that's the reason. So thanks a lot.
Okay, not seeing any more questions or comments by the committee, so with that, we're going to go ahead and adjourn. Thank you very much for coming out.